My topic today is international trade laws under WTO. The purpose of this lecture is that the legal fraternity must be aware of the paradigm shift of international trade legal principles, law, and practice from original mercantilism to the present system of international trade under WTO. Now, the most important thing of WTO, as I consider, is its dispute resolution body. That any dispute that occurs between the contracting parties may now be taken to the dispute resolution body for dispute resolution through the petition to the dispute resolution body and then its findings. Now, actually, this made a paradigm shift from private international law principles to the present system. Now, international law is called a vanishing point of jurisprudence that all of you know, because it doesn't have a sovereignty and it is not binding. Even the decision of the World United Nations organization, even that body's decision is not binding on the parties automatically unless they take their actions. So therefore, the sovereignty is predominant in the evidence of the international treaties. Whereas in WTO negotiations and the WTO establishment, it has been now a kind of a sanction that can be imposed upon. A sanction can be imposed upon by a party not fulfilling the obligations under international trade laws. That means that the concept of sovereignty is restricted by the agreement, and also the concept of binding character of international body is now finally accepted. Actually, this was done at the behest of India's Prime Minister, one of the India's erstwhile Prime Minister, when he was dealing with apartheid of South Africa. And his argument in the United Nations was that if the South African nation, the regime of the time, follow the anti-apartheid principle, then as an anti-apartheid measure, the other nations can impose sanction, trade sanction. Now from that, actually it has been transcended and landed in WTO. So dispute resolution body's decision, panel's decision, is binding now. And on that basis, you have actually the decision can be enforced. Now, in India, India being a party, now WTO in its dispute resolution body up till now has accepted 588 disputes, of which 25 disputes are against India, 25 disputes are against India, and 22 disputes are by India raised against other countries. So these are 47 disputes that have been raised. Now it is found that very rarely the sanction is applied and granted. Very rarely. Now in fact, there is only one. Now let me give the stages. Once there is a dispute, the contracting party being affected applies to the WTO dispute resolution body to form a panel. Along with that panel, they also request for continuing their consultation process with the other contracting party involved. Now, this is the first step. Now, then the panel is formed, panel is composed. While composing the panel, both the parties are heard, and with the concurrence of both the parties, a panel of dispute resolution is formed. After the panel is proposed, panel then uh, have the consultation process goes on, and most of the time in this consultation process, the disputes are resolved. Uh, the third stage, we find that the panel submits the report. The report can be appealed. Then the third stage, there can be an appeal. If the country prefers to appeal, they can go to the appeal. And after the appeal, they can take this to also the arbitration proceedings. After the appeal decision been given, against that a party may go to even arbitration option and enforcement, or it may also apply, the other party may also apply to the dispute resolution body for giving the power of sanction, giving the power of now giving the power of enforcement. This authorization of, it is called authorization of retaliatory measures. So they may retaliate. Now I find out of this 25 applications against India, only one has been taken to retaliatory police. It is formed by US on certain measures relating to solar cells and solar modules. The consultation failed. Panel gave a report. After panel's report, it was appealed. Appeal against the appeal. India could have taken the matter to arbitration, but did not. The US actually filed to authorize it to take retaliatory measures. So only one out of these 47, only one has gone to that stage. Most of these other things are settled on consultation, and then only two have been taken to the arbitration proceedings under Section 22(2) of the GATT negotiation, GATT treaty. So this is the mainly the feature of dispute resolution body. But we will come back to this dispute resolution body a bit later. Now, WTO, actually, the negotiation started in 1948 when United Nations were formed. At that stage itself, US and UK, they privately consulted, mutually discussed to have an international trade organization, ITO, International Trade Organization, within the framework of United Nations. So the negotiation continued, but negotiation failed. This bilateral process did not take hold. Instead, the GATT treaty was accepted in 1948. GATT treaty, General Agreement on Tariff and Trade. This GATT treaty was then accepted in 1948. And this GATT actually was a negotiating platform for ultimately having the council. Ultimately having the council, that having the International Trade Organization, ultimately, but it did not come to in that name at all. Ultimately, it came into the name of World Trade Organization in 1994. So in 1994, in the 8th round of Marrakesh, WTO was formed. WTO was formed for several reasons. The first reason was that it has to implement, or it has to oversee the international trade regulations. That means earlier in mercantilism, the most of the international trade was by the process of bilateral systems, and it was part of the private international law. Under the present system, it is a multilateral system. Therefore, international trade takes place within a legal framework. And this legal framework gives a character of public international law, as a matter of fact. So mercantilism has ended and WTO regime has started in 1995. Now, if you look at that, WTO has got first responsibility of making the law, making the rules and regulations of international trade, multilateral international trade, making the rules and regulations through rounds. Rounds are generally taken place in every 4 years, once in every 4 years. So from 1948, every 4 years, there were rounds. And the eighth round, the present WTO was formed, and the present legal systems also was accepted in the eighth round. So eighth round then comes into in 1994, and then it comes into operations in 1995. So WTO's first job was making this rules and regulations of multilateral international trade law. Second, the tariff has to be reduced. Now, general principle, when the debate started on economic principles of argument of trade, argument for free trade, and argument against free trade. Now, there are several arguments of free trade, but importantly, what was accepted. Why you are doing this? So when actually argument of free trade was that only free trade can make uniform economic development. Uniform economic development, that means one can move from the most developed countries to developing countries and the least developing countries. In that, it can freely move and it benefits the entire market. So if trade is free, actually the economy of the developing countries as well as least developed countries may also develop rapidly. This was the primary argument which was accepted, but that this least developing countries and developing countries, they suffered their economic stumbling the last 200 years, more than that. Some are more than that, some are chronic. Now, in this process, there was this equation of economy, and therefore, in this imbalance of economic systems, WTO or ITO could not be established at that moment of time, because though it is accepted that international trade, free international trade exchange of goods and services without any barrier, tax barrier, without or least tax barrier, and without any non-tax barrier, if goods and services move from one part of the world to the other part of the world, then we find that economic development would be better, employment opportunities would be better, income would be high, GDP growth rate would be high, and therefore this was the argument which was accepted by all, accepting that developing countries wanted time. Now, naturally, developing countries time was through dialogue, and the dialogue platform was the platform of GATT. So GATT 1948 was taken as a platform for negotiation of international legal principles, multilateral international legal rules and legal principles. That was the WTO's first job. The second job of WTO, obviously, was to have its day-to-day operation. Now, initially WTO has the rounds every 4th year, ministerial rounds. These rounds every 4th year determines the legal principles, multilateral legal principles. Then every second year, every end of the second year, every 2 years, they have a ministerial conference. Ministerial conference overviews and also considers the standards that has been followed over the time. And then day-to-day operations are done by General Council, and General Councils are generally represented by the ambassadors and the delegates. Now, this is the pattern, WTO's pattern of administration. As you know, WTO established in Geneva, so Geneva office maintains this pattern. And it has the Secretary General, which sees the entire administration and oversees the legal principles being followed. Now, once this is multilateral treaties are there, now some of the basic thing in the multilateral treaties was this. Now, two principles are very important. One principle is called most favored nation principle. Now, this is based upon, again, two legs. One leg is called doctrine of equality. The other is called non-discrimination. Doctrine of equality means that if one contracting party gives any favorable condition, extends any favorable condition to another contracting party, then in that case, automatically all the other members of that GATT would be having that benefit extended to them. So this is number one. That means you cannot, as a matter of fact, give one bilateral favor to only one country, because if you just give one country one favor, one concession, the favor and the concession would be applicable to all other nations. So that means everybody has to be enjoying the equal privileges, the doctrine of equality. And there has to be non-discrimination, which buttress that, positive and negative conditions. That means no country can extend any discriminatory provision against any other country's trade relations. Now, this is non-discrimination, because once you don't discriminate, then unevenness in the market game rule will start. So non-discrimination means you try to discriminate by a favor or by a reduction of rates. It will apply to all other countries on the principles of equation at the same time. This is called what is called Article 1 of, but there are exceptions to Article 1 as well. Now, Article 1 says that there are regional trade councils. Now, there are some cases of historically, some cases of additional privileges being given to a treaty of plurilateral treaties between some countries, or regional treaties in some members of the regional treaties amongst themselves. Like, say, SAARC countries may have some additional privileges. Now, in that case, it is permissible, provided these are in the schedule. Lists are given in the schedule. Now, I said SAARC. In this case of SAARC, the SAARC countries are not in the schedule. So, if we have to have a trade negotiations within a regional council, then in that case, A, it should be within the list as in the schedule, and if the list schedule are there, then in that case, the privileges can have in the form of a duties by not more than the existing rate of the duties and of a country, highest and the lowest that privileges is entitled to. In that, there is a difference of 12% generally. So it cannot exceed more than 12%. Now, this is exception. There are some exceptions. These are exceptions. As for example, least developed countries may have certain more privileges, both tariff and as well as non-tariff. Similarly, new countries joining the WTO. WTO at the present moment has a membership of about 164 countries, and 20 are in the waiting list. So there are therefore 184 countries which generally abide by this. 20 they have to abide by pre-membership adherence principles. So they have to abide by the WTO's rules and regulations. So 184 countries are now following the trade regulations, which is almost 98% of the international trade, or more than 98%. It will be 98.5% of the international trade. And therefore, WTO now actually regulates, I will say not regulate, but monitors or oversees the trade relations of 198 countries. Having said that, I said the second principle, second job of WTO is that it generally not only makes rules, but also enforces the rule, or makes the, biannual report of status report, biannual status report through reporters, and places before the committee, before various committees. So this reports actually looks to the present ground reality. What is available in the ground, the reality conditions are given. This is the second one. The third is that WTO has a dispute resolution body. As I already said, that dispute resolution body. This dispute resolution body appoints a panel, the panel to decide, panel to take a decision in case of a dispute between the two contracting parties. Now, most of the contracting parties have got the disputes over tax barriers or non-tax barriers, or privileges, extra privileges, or extra retardations. Now, the two very important ground on which disputes come to this platform are called dumping and therefore anti-dumping measures. Now, today we will develop some more ideas of dumping and anti-dumping and countervailing duties. So, dumping and anti-dumping and countervailing duties. Now, there are other conditions also. Non-tariff barriers, also non-tariff barriers are also there, on which also there are a lot of disputes between the parties. Now, from 1991, this dispute resolution bodies are formed by GATT as well as WTO, following the inheritance from GATT. Now there are 581. There are 588 cases total. In the initial period before 1995, there was no sanction. That means taking retaliatory measures were not there. This right to confer the one party contracting party to take retaliatory measures was not there at that time. After 1995, there are 13 cases. Before 1995, there are 12 cases. So this 25, total 25 against India. I'm talking about only against India out of 588 total number of cases. If you look at this, if you go to review, you will find in the dispute resolution, initially it was United Nations were taking the recent years. China is a major player in raising disputes. Now, India's most recent dispute resolution groups are coming from Taipei, and that is on integrated circuits. So we have to look into that integrated circuit sometimes afterwards. But at the present moment, this is what is dispute resolutions, and this is how dispute resolution takes place. This is the third task of WTO. The fourth task of WTO is that with the assistance of UNCITRAL, it makes the international trade laws or draft trade laws for the purpose of leading the least developed countries and developing countries, for the purpose of helping them, least developing countries and developed countries, least developed countries and developing countries, for their, to enhance their, for making them entitled to the legal regime. UNCITRAL makes the rules and regulations, draft rules and regulations, which are given to WTO through WTO mechanism. These are then held, and sometimes these least developed countries and developing countries are directly helped in drafting their own legal regime in consonance with the international rules and regulations of WTO by the WTO itself. So there are four powers, general four powers of WTO. Now, let us now come to the challenging task in WTO, which lawyers have a role, big role. Lawyers have a big role in two senses. One, that lawyers have a big role to position Indian lawyers, particularly. They have three privileges. A, they are strong in English. we are, our whole legal education is through English, and therefore we are English-speaking world, and therefore the in the litigation processes itself, we have a direct role, both as preparing documents as well as arguing and interpreting. The B, that we follow the common law principles, because our legal systems are common law legal systems. So we follow the common law principles, and common law principles are actually the principles of litigations, of day-to-day litigation forum of dispute resolution bodies. And 3, this Indian bar is quite competent to handle international arbitration. Under WTO, particularly in Rule 22(1), the matter can be taken, ultimately matter can be taken to, that's the one window given to the parties suffering from the decision panel's decision, that it may take it to arbitration also before it lands up into a kind of retaliatory measures. It can take it to the arbitration also under 22(1). So this arbitration, one of the strong field and field. So let us try to understand 2 or 3 cases. In one case, this is the case on White Australian Limited versus Government of India. It happened like this, that when Coal India was trying to restructure itself because of enhancing the power of the Indian coal, so they require certain treatments, and these treatments require certain machineries. And the machineries are available in Australia at a very comparable rate. So negotiations are going on in 70s and 80s, and then during that time, White Australia Limited actually helped the negotiator, this called this Coal India. So negotiator Coal India at that time was absolutely state body, state sponsored body. So Coal India was negotiating for the instruments. Instruments were costing something about 800 million Australian dollar. Now, Indian government found difficulty in arranging for the fund, and negotiations were piloted by White giving consultancy support to Coal India. And White being an Australian company, it knew the funding processes of Australian companies. So ultimately, there was a mutual agreement between funding agency, Australian government funding agency, a bank, and which agreed to support the investment in India. And White actually got the contract for actually transporting the entire machineries to India, payment being made by the banks, Australian bank and the government agencies. But they have to train the Indian staff. They have to internalize the principles. They have to also functionalize the machineries. And in that process, there are 2 agreements with this White. One agreement was that if machineries are planted and the operations are done, and if they succeed in the targeted producing amount, targeted quantum, then they get a bonus. And if they fail to do that, they give a penalty. Now this, over the years, about 6 or 7 years during the transition, Australian company, they have claimed that they have earned something about 2.8 million Australian dollar by way of bonus, and penalty was something about a few thousand Australian dollar on account of penalty. So Australian company demanded this money from Coal India. Coal India refused to pay. Instead, Coal India, when the machineries were transported, there was a bank guarantee given by the Australian company White. Now they invoked the bank guarantee and took about $2.5 million from that bank guarantee amount. Now Australian company demanded something about 4.7 or 4.8 million Australian dollar and filed a case because the agreement showed that they abide by the decision of the Indian courts. So they filed a case. The entire agreement was under international treaty, Indo-Australian International Treaty. And in that treaty, it is an investment treaty, IT. It is an investment treaty, Indo-Australian Investment Treaty, in which there was a condition that Indian legal system, being a common law system known to Australians, and therefore they will abide by Indian courts. But in case there is an arbitration would be under ICC rules, and arbitration site would be Paris. Now, Indian company filed White filed a case in Calcutta High Court. White filed a case in Delhi High Court claiming the amount, whereas Coal India, after the filing of the case in Coal India filed a case, almost simultaneously filed a case in Calcutta for staying for injunction on claiming the amount. So in Calcutta. Now these two processes simultaneously was carried. Now Australian company, White and Company, went to Supreme Court, asking Supreme Court to intervene and take away both. Supreme Court intervened and took it to Supreme Court, but then thereafter said, all right, after the decisions of the court, you can come. Now, court continued. Delhi High Court has given the order in favor of the White and Company, whereas Calcutta High Court stayed the order. Calcutta High Court stayed that order for the time being until it's decided. Now, all this, made a mess, and then when they again came to the court after the decision of the Calcutta High Court rejecting this appeal, rejecting the claim of White, they came to the Supreme Court. Supreme Court first have a two judges bench, and two judges bench continued for 1 year. Then they shifted it to 3 judges bench of the Chief Justice of India. Now, in the process, there were 7 years delay. Australian company now under IT as well as dispute resolution systems of WTO wrote to Government of India that let there be an arbitration. They want to have an arbitration. Government of India accepted arbitration proceedings straight away and nominated its members. Australian company also nominated its members. Both of them nominated somebody from England as the third umpire member. Now, this decision, this arbitration was done instead of Paris. For the convenience of the parties, the the hearing was made all in London. Now, after that arbitration in 2-1, India tried to say that there will be bias. Two arbitrators were biased. So fearing that they were biased, they wanted to have another arbitration board. But this was not done. As a result, the arbitration proceedings continued. And in 2:1, the arbitration award was given for asking the Government of India to give about $4.5 million to the Australian company. Now, this shows that WTO has also, through arbitration, takes a matter for enforcement. Now, WTO can also, the dispute resolution go to dispute resolution body also have given the arbitration under 22 section 20, clause 22. Now, these arbitration proceedings can then also be enforced. Now, it shows that there is a possibility of now a dispute resolution body enforcing the decision. This is what is important. The second case that I already told you is the solar panel case, where US solar panel case, India provides a subsidy. US, since India provides a subsidy, there is some unevenness against the. So there is a case by Australia and by US. US found a petition to the dispute resolution body. The panel was made. The panel gave the report. The report was not appealed, and after the compliance, they're having no non-compliance. US sought the permission of authorization to take retaliatory measures. This is also now a new incident, which retaliatory measures has not yet been taken, but authorization has been asked for, and obviously WTO has now the teeth. Generally, we say international law doesn't have a teeth. So it is a vanishing point of jurisprudence. It doesn't have a teeth, no enforcement mechanism. So now we have economic sanction process. The sanction process is then a sufficient retarding measures. Now, since we have discussed about that, then most of the litigations at the present moment start from tariff and non-tariff barriers, and therefore dumping and anti-dumping. Now, dumping and anti-dumping, in case now Indian Authority of Dumping Authority or Anti-Dumping Measures Authority or Investigation Authority is the Government of India. On behalf of that, the Government of India notified a joint secretary level person responsible for the dumping and anti-dumping measures. Now, dumping, if you look at generally, people, the countries wanting to give protection to its own industry, generally have this tariff barriers or non-tariff barriers or both. Now, or export promotion duty back, dumping attempt. When a country dumps its product in the process of exporting to another country, the exporting country which is importing the goods, they can then consider that this has been dumped. This has been dumped. So when this dumping is claimed, the contracting party may then take a provision of imposing anti-dumping duties, and also countervailing duties too. I said anti-dumping duties, but for anti-dumping duties, one has to prove that there has been a dumping. Now, what do you prove? That that the contracting party in exporting country has taken less than the normal value of the product in their own market. This is number one charge. If the product in their own country is X, then it is sufficient to prove that it has been exported into that country, or the country imported at a lesser price, X minus percentage, to that country. That's number one. And the number two is that there has been a material injury caused to the economy. There has been a material cost to the economy, which materially returns the establishment its own industry. Materially returns its own industry. So this is to be proved. Now, generally, what happens, the country which imposes, or before imposing, the authority gives a kind of an opportunity of hearing to the other party, the other countries, the exporting country, and also get the list of the same commodity or identical commodity, or identical similar commodities or likely commodities, their contracting price, the market value of that in that country. And the second is that on what basis you have charged this amount. Now, generally, if it is found that cost of production is higher than the cost of sale, then the country exporting at a lesser price than the manufacturing or total cost price would be a dumping. Now, total cost means what? The cost of production, direct plus indirect overhead charges and marketing costs, or marketing overhead. Altogether, we call total cost. If the total cost is X and you have exported into that new country, the importing country, at a lesser price than X, then this is considered to be a dumping. Now, this initially it is facts are supplied by the other contracting parties, but most of the time the matter goes to any solicitor's firm to have an investigation done. Solicitor's firm generally collects all those informations and supports the authority with those informations. Supports or rebuts, both are possible. This is obviously a paralegal, most important paralegal activities, which is at the present moment generally done by many chartered accounting firms, but I think law firms also can have a look at it, and some of the law firms are already doing that in India. This is one of the interesting area, because more and more time we'll find that some of the countries which can monitor their own cost price by several methods. One of the methods China generally followed was pegging its fixed currency value. So it has a fixed currency value in terms of dollar, and then since fixed currency value, it doesn't have a regard to the market value at all. Now, at that price, obviously, cost of production would be less than actual cost price had it been in the dynamic valuation system of IMF. So this is one method. The other method is that you have generally do not follow labor code. The ILO has got several labor conventions. Now, many of the countries generally are not following that labor conventions, or they do not have a favorable labor code. So you give the labor cost less. Now, if you give the labor cost less, and it is calculated that the labor human value attachment to this cost is this, then also it is a kind of methodology adopted for dumping. Now, there are protections given dumping. Say, for example, export subsidy. India has been taken for this export subsidy, import restriction, export subsidy, import restriction, or duty on import, excessive duty on import, all those discriminatory duty on import, all this shows that you are following a protectionism in your economic parlance, which is antithesis to international free trade. Having said that, what is countervailing duties? Now, the first is that power of the country importing the country, if they can prove that these are the two things that are happening, and their own market, their own industry is having a retardation effect, then in that case they can impose anti-dumping duty, so that you then repairs the dumping attempt with the anti-dumping duty, makes it equal. Now, while making this anti-dumping duty, therefore, it has to have a kind of procedure followed. The procedure, anti-dumping inquiry investigation procedure is also there. Now, dumping procedure is there, so that anti-dumping duty can be imposed. The second one is countervailing duties. Countervailing duties are not actually supplementary to the anti-dumping. Now, a system of stabilization for domestic prices of the return of domestic product producers of a primary commodity, independently of the movement of export prices, which results in sometimes sale of commodity for export at a price lower than the comparable price charged to the like commodity to the buyers. Now, in such a case, if it is found that there is some way of compulsion, then perhaps then the country which is suffering from it, may impose also uh, a duty called countervailing duties. Now, there are, of course, detailed procedures of calculation of dumping, effect of dumping, and procedures of charging anti-dumping duties, as well as countervailing duties. Now, this is a new area. This is a very interesting area which opens up the methodology of litigation management, both at a pre-litigation period by documentation period, and after the documentation period. Now, if you have this, you can then now go for understanding something about uh, determination of dumping. How do you determine the dumping? How do you determine the dumping, impact of dumping? There are, of course, as I said, impact of dumping is that there are one is that direct impact, the other one is that called causatory impact. One is impact immediately to be followed, that your price, market price, has gone down by artificially subsidized import of goods from outside, so that your industry, the main impact is on your industries suffer. Now, it all therefore relates to the market price mechanism, free market, as well as what ought to be the market if there is no dumping effect. For the short, appetizer, this talk is only for the purpose of giving basic information to the listeners, not an advanced one. Once you have this, basic information, then we topic wise, side by side, we can take the knowledge further forward. Thank you very much.